Landlords and tenants, I have collected 5 articles of law that I believe is very important for you to be aware of when signing a tenancy contract.
In this video, we're going to walk you through them step by step so you know exactly where you stand and exactly how they affect you.
Enjoy watching. Hi and welcome to Dubai Property Legal Guide, a series of videos I'm making addressing the most common concerns and issues discussed with me by property owners, landlords and tenants, as well as property brokers. Joining me today is Michael from my social media team. How are you, Michael?
I'm doing very well, thanks. I'm very glad to be back. This is a very interesting video because in previous episodes we've discussed things like the Ijari, tenancy contracts, some sort of landlord-tenant obligations.
We did.
In this one, it's going to get a bit more technical. So are you ready?
I was born ready.
Excellent. So we're going to be talking about the rules that make up the law that we've been referencing, this law number 26 of 2007. So let's get right into it. I'm just going to read it out again so everyone knows which one we're talking about. Law number 26 of 2007, regulating relationships between landlords and tenants in the Emirate of Dubai. So if you'd like to take us through the articles,
Sure.
we'll get right into it.
So the articles that we're going to discuss, Michael, today is a random article, yet very important. There are points that people, especially landlords and tenants, need to be aware of it when they are signing a tenancy contract. It mainly affects in certain occasions. We're going to read through it and we're going to elaborate more in practice. Article 27 from the same law that you mentioned, if a landlord or tenant dies, tenancy relationship shall devolve to their heirs unless tenant's heirs decide to terminate the relationship. This shows that what will happen in case of any of these parties deceased and their heirs will be taking over the relationship. It doesn't mean that the tenancy contract will be cancelled or expired or anything as such. Article 28. The transfer of title to a new landlord shall not affect tenant's right to continue occupation of the premises in accordance with tenancy contract signed with the previous owner, provided that the tenancy contract has fixed date.
So I'm just going to jump in there. I'm going to reference back to a previous video where you mentioned that upon expiry of the lease term, the landlord has to have given 12 months notice to ask a tenant to leave. So let's paint the picture. The landlord changes, the tenant is still in that property. If the new landlord wants the tenant to leave, they still have to give them 12 months notice before they can do so.
Yes, because when a new buyer is buying a property, it means that they are buying the property knowing that this property is already rented to a third party. So when you are buying it, you are aware of this situation. Therefore, you are accepting and confirming the relationship to continue. Now, if the landlord wants to end this relationship, then they need to send a legal notice to the tenant and confirm that they want them to evict the property upon expiry. Moving on to the other article. Article number 29. Number 1. Tenant shall have priority to return to the premises if it's demolished or reconstructed or if it is renovated, provided that the rent value shall be fixed in accordance with Article 13 herein. Section 2. Tenant shall benefit from the above-mentioned priority right within 30 days from being notified by the landlord.
And in this situation, it could be anything. If the property is deconstructed, there's a villa in Scheme 3 and it gets demolished, it's then rebuilt. Within 30 days of that property being rebuilt, the landlord's given notice, and within that 30 days, the tenant has to decide whether they're going to come back or not.
Absolutely. So what happens in practice is that the landlord will ask the tenant to evict the property because they're going to demolish it, renovate it, restructure it, do whatever necessary needs to be done. But then the tenant has to move out. And obviously the renovation and demolishing, it takes a long time. When the property is back up and ready to be rented, the tenant will have the first right to occupy the property back again. What happens is that when the property is totally ready and they got their completion certificate, the landlord will send a notification to the tenant and inform them that the property is ready. Do you want to rent it? And they will give them 30 days. Within this 30 days, the tenant has the right to accept and then sign the tenancy contract with the landlord. If they don't, then the landlord can just go and rent it to someone else. Moving on to the next article, Article 30. If the committee orders, the committee here is referring to RDC, Dubai Rental Dispute Center. Yeah. If the committee orders termination of tenancy contract and the premises was occupied by subtenant in accordance with the contract signed with the tenant and approved by landlord, then the subtenant shall have the right to continue occupation of the premises with the same conditions.
So let's talk about the word subtenant here. In a previous video, you've mentioned that subleasing is allowed only with prior written consent from the tenant and the landlord. So what's the difference here? Because you mentioned that the subtenant could be evicted and...
So true. So in that situation, we were talking about a tenant subleasing the property to a third party without written approval of the landlord. So if the landlord becomes aware of such arrangement, they will go and ask eviction of the tenant and eviction of the subtenant as well, because this was not sanctioned and blessed by the landlord. But in this situation, we are saying that the sublease was signed with the tenant and approved by the landlord. So it's as good as the landlord has signed with the subtenant.
Right.
So in this situation, the subtenant will have the right to continue, considering that the landlord has already agreed with this sublease. Yeah. So that's why they can, and this is the only difference with that previous topic. Article 31. Filing an eviction case shall not relieve tenant from paying rent value for the whole period of case until the issue of judgment and execution thereof.
I mean, that makes a lot of sense, but even that sounds almost quite scary, because that's a long process from the dispute happening right the way to the execution. That can take quite a long time.
Yeah, but Michael, don't forget that the tenant is still in the property. They are using the property. So in most cases, the tenant thinks that, okay, as long as he or she filed for eviction, it means that I will not pay the rent amount anymore. No, you have to continue paying the rent till the judgment is issued and the property is evicted, or whatever judge decides about the rent. That's what's going to happen. But in general, the tenant, as long as the judgment is not passed and eviction has not been concluded, then they need to be responsible for paying the rent. These are the terms and articles that I thought is very important for people to know, because normally I've seen clients, they are not aware of it, and it raises some concern. In general, there are other terms and conditions that in practice we advise our clients on how to go about it, but these are the main ones that I thought to discuss it today.
Well, it certainly sounds important, and I think these are a couple of points that could really catch someone off guard in process if it comes up. But for the purpose of these 5, I think we've covered everything, so it's back to you.
Thank you, Michael. Thank you so much for watching this. If you have any questions about any of these articles, or in general about tenancy contracts or real estate matters, feel free to send me an email to arash@zollaw.com, or send me a direct message on my social media platforms. Thank you for watching this, and I'm going to see you on the next episode.